Tonight we're talking Ask Us Anything, and actually we did get a couple of emails in over the break. There was one that our producer just sent to me. It says, when I moved into this apartment, I never had respiratory problems. It has flooded twice from the drain backing up. All the landlord did was wet vac. I have bronchitis 3 times since. I didn't get the rest of that. My landlord told me my claims of mold are unfounded and maybe I'm crazy. Any advice? Okay, so Brian, that's from Billy. Billy's in an apartment that's got some mold and water intrusion issues, it sounds like, and the landlord's not doing what they're supposed to do.
Well, the first thing, and I've given this advice probably a dozen times in the past year, is if you have an issue and you're renting, you need to put your complaint in writing to the landlord.
Right.
Because most people are friendly, you talk to them, you say, hey, can you fix this problem? And when the landlord doesn't do the right thing, which is few and far between here in Bay County in my experience, but when they don't do the right thing, you say you made this complaint and then you're trying to get out of your lease for whatever reason, and then if you break your lease and don't pay, you're gonna owe money.
Right.
So the biggest advice in that situation is put the complaint in writing, and then if you are living somewhere that is unsafe, the landlord has an obligation to make sure it's reasonably safe.
Right.
I don't know the actual landlord-tenant language, but basically you shouldn't be exposed to mold.
There's basically an implied warranty of habitability.
Yes, that's the word.
That's it. See, I remember they taught us that in law school.
Yeah.
Were you absent that day?
Once or twice.
Okay, probably fishing. Yeah, so with every lease, every landlord lease agreement, it is implied that you're paying them money, they're going to give you a place that is suitable for you to live in. It's called an implied warranty of habitability. Anything that they do or don't do that can create an issue of your quiet enjoyment of habitability.
That's not exactly the right word, but
close
okay.
Close enough. That could be a basis for you to break the lease, but there's a lot of process that you have to follow. And Brian mentioned the most important one. Any sort of a complaint you have like that, you want to put it in writing for 2 reasons. Number one, you want to show that you've actually made the complaint. You want to document those attempts to get it fixed. And number two, I mean, there's going to be a paper trail that you're trying to create, because eventually this may go in front of some sort of a judge or jury, and you want to be able to show that you were trying to do everything you can. You're using your best efforts to try to get this problem fixed, and the landlord was not following through. Now, that doesn't mean that they're not going to come after you for rent. It doesn't mean that you might have to pay some things in the meantime. There may be reasons for and against doing that. Every case is different. But Billy, in your case, if you've got an issue and there's clearly respiratory problems coming from this, it sounds to me like number one, you need to put the landlord on notice that, if this doesn't get fixed, you're going to be breaking your lease so you can get out of it. Now,
Yes.
We have people call us also and say, well, I've got a mold injury claim. And I think it's from exposure to an apartment or a townhouse or someplace I'm renting, or it could be someplace I'm working, but people come in and they have mold-related illnesses. There's also a legal basis to pursue those types of claims, but they're pretty heavily specialized. And there's a lot of medicine and a lot of science that goes into proving causation, which is one of the most, really, in a case like that, that is typically the one issue that we have to wrestle with on whether or not we have a viable case or not. So when we're talking about causation,
100%.
What do we mean?
So causation, if I trip and fall and break my arm, everybody knows it's from falling and breaking an arm. If you get sick and you get pneumonia and you're claiming it's from mold, well, people get pneumonia without being exposed to mold.
Right.
So you basically, in those situations, you need medical documentation from a doctor. And there's tests where they can actually confirm exposure to mold, and that will line up with the symptoms. But we have, I personally have cases where there's a car wreck and somebody has a very unique injury after the fact. It could be cardiac related, it could be brain related, like a TIA or something like that. And you need to hire a lawyer to go confirm and consult with doctors or experts to see if those conditions that are very serious and happen after a wreck are actually caused by the wreck. Because I've had cases where somebody discovers a brain tumor as a result of a CT scan, and essentially the car wreck saved their life, and they learn.
I've seen that too, yeah.
About those are incidental. So just because you discover a condition after a car wreck, a fall, living in an apartment, doesn't necessarily mean it's due to some negligence or some other cause.
Right, and that happens before. I've seen multiple cases over my career where somebody gets an MRI of their low back and it happens to pick up a spot on a kidney or something different, and they go, well, your low back looks good, but we need to look at this spot that's looking a little suspicious, and lo and behold, hey, I would have had no idea I had this tumor but for the fact I was involved in a car wreck. Now, that doesn't give the at-fault party the right to go, oh, see, I saved your life. They can't do that. But sometimes that sort of thing happens. It's not as rare as people think.
It's not as rare as people think, but just because you find the tumor after the fact doesn't mean the car wreck caused it. Now, a tumor is an easy example.
Right.
A heart attack the day after a car wreck, it depends. It could be caused by any number of things.
Right.
So if you have one of those unique incidents or injuries after, or even the mold exposure, it's best to definitely consult an attorney, and they can walk you through what we have to prove. And it's relying on doctors and medicine and science and things like that.
Right. And in order to consult with an attorney like us, it doesn't cost you anything. I mean, we talk about free consultations all the time. Anybody that has a question or they have a claim that they want to talk with us about, they schedule an appointment, come and talk to us. There's no cost whatsoever. If we are allowed to take your case, or if it's a case we think we can pursue, you don't come out of pocket to pay us for that either. We work on what's called a contingency fee basis, which is if we make a recovery that you, the client, agree to accept, then our fee is a percentage of that recovery. And the Florida Bar establishes what the fees can be and has basically said that 1/3 of the recovery for a pre-suit settlement is a reasonable fee. And so that's typically what it is. If we don't make a recovery, then there's no fee whatsoever. But there's also the issue of case costs. I know before we took the first break, you made the comment that even on a very basic case, you're looking at spending $10, $15, even $20,000 on a regular, run-of-the-mill garden variety car wreck case, which is a lot of money, but the clients don't have to front that money either. We will typically front that for them. But how do you end up running up those type of case? I mean, what are some of the things we have to think about buying or spending money on just to present a case that a lot of people don't really think about?
And before a lawsuit is filed, our case costs, I tell my clients, this are relatively low unless we got to hire experts for accident reconstruction or something like that. It's medical records, bills, crash reports, or paying our investigator, things like that. But once you file a lawsuit, just to file and serve a lawsuit, it's $432.40 to file it, and then you got to pay a process server to serve the lawsuit. So you're already at $500. And between deposition fees, court reporter fees, transcript fees, and then videographer, depending on the witness, and then go into mediation, we get to $4, $5, $6 just to take basic depositions and get to mediation. Because mediation, some of our mediation